And Mr. Burbank, will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
Mr. Hill, in cause number 24, DCCR 1614, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from July 15th of 2024. And how do you plead to that charge?
I'd like to plead guilty and take responsibility for my actions in this case.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
All right, and then in cause number 24, DCCR 1615, you're charged with a first-degree felony offense of aggravated robbery from July 15th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Correct.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Correct.
And it looks like the agreements that you've reached is for a 10-year deferred probation in each of your cases. Fines?
It's to be determined by the court judge.
Okay.
Up to the-
There would be a fine as determined by me in each of those cases, and the state would dismiss as part of that agreement cause number 24 DCCR 1500. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case?
No objection, states one in each case.
It's admitted in each case. Is there any evidence that Mr. Hill is not competent?
No, Your Honor.
All right, Mr. Hill, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That will give me more information about you, your cases, and then we'll come back at a later date for sentencing.
Yes, ma'am. Could I motion for a waiver?
No, we're not gonna, there's no waiver in a first-degree felony of pre-sentence report. I'm going to get that report. I'm also not going to adjust your bond at this amount based on the nature of these offenses until I see what those that report looks like.
And Your Honor, I want to address something the court's going to see and going to ask me about in
Okay.
about 5 or 6 weeks. His jail disciplinary history is about as bad as you'll see. That needs to be immediately addressed. I anticipate asking the court for some programs to address his behavior, but I want to let the court know and let him know he's threatening guards, spitting on guards, threatening to dash guards, dashing other inmates, literally climbed the walls of the day room while they tried to place him in restraints.
These are fraudulent claims, Your Honor.
Let me tell you something real quick, Mr. Hill, all right? And this isn't going to be some negotiation and talk back and forth. You need to listen very carefully to what I'm about to say. If you have another incident report between now and when you come back for sentencing, I am not required to accept this plea agreement.
Correct. Okay.
I don't have to.
Yes, ma'am.
We can let a jury decide if they think a probation's what you need for an aggravated robbery and an aggravated assault.
Yes, ma'am.
Because my guess is they might not.
Yes, ma'am.
They would just go ahead and send you to prison, especially because at a trial, they will see the same things that I see at sentencing, which is every one of those incident reports from the day you got in. That jury will see that. I will see that.
Yes, ma'am. They haven't given me an option to waive.
What did I tell you? This isn't this isn't that. Those officers out there are doing their jobs.
Yes, ma'am.
They're trying to go make a living and go home to their families.
Contrary to belief,
Hold
I have a
on.
really good
I'm telling you right now.
relationship with most of those guards.
Stop talking.
You know,
That's your second warning. I can reject these right now. We can set your trial.
I would-
Is that what you want to happen?
I'm not.
Then stop talking. I told you this today is just going to be a listening thing. I have a feeling that's part of your problem in jail, is because you won't just sit and listen. You are there because of your actions. They are doing their jobs. Grow up, because you're in big boy court. You're a grown man now for our purposes. And stop acting like a little heathen out in our jail. Or we will let a jury decide what to do with you. It's that simple. You can go back with the bailiff.
I'll see you out there.
This is Mr. Coleman's.
Sorry. You got it?
Good morning, sir. Are you Romeo Johnson? And Mr. Johnson, in cause number 24, DCCR 2095, you're charged with a first-degree felony offense of aggravated robbery from September 7th of 2024. That indictment alleges that you were previously convicted of robbery March 9th of 2015. And what that means in that case is that if you go to trial and you're found guilty, you would be considered an enhanced offender, which means your minimum punishment would be 15 years in that case, up to 99 years or life. Do you understand?
Say 15.
15 minimum.
Yes, ma'am.
And the paper that you signed was checked off with just the regular first-degree felony, but I want to make sure and let everybody know I have made that notation that it would be enhanced if that prior one is true, and you understand that that minimum punishment would be 15 up to the rest of your life. You understand? And then in cause number 24, DCCR 2419, you are charged with the first-degree felony offense of murder, and that's from October 14th of 2024. It looks like there was a notice filed December 30th of 2024 by the state that alleges that you were previously convicted of robbery, the one I mentioned in that other case from March 9th of 2015, that you were also previously convicted of evading arrest or detention with previous convictions in cause number 20-34416, April 13th of 2022.
Judge, I believe that was
That's
a
a state
state jail
jail.
felony, so it doesn't,
But it was enhanced to third degree.
Was it enhanced by that robbery? I would assume.
I think punishment level would have been enhanced.
It would have had to have been, well, it would have had to have been, to be a third, it would have had to have at least,
It looks like we had 12 months state jail in 12 months state jail in 13. So the two state jails would enhance the state jail.
so
absent
that's a
the
third
robbery.
degree.
Yes, ma'am. That
Right.
would be without having the motion.
That's what it sounds like. So if you had, in April 13th of 2022, in cause number 20-34416, can y'all look that up please for me real quick? 20-34416.
And I could be wrong, Judge, I just didn't see any other, I saw where it was enhanced, but
Well,
not
the
the
two
actual offense level. just
Let's
the
look at it,
punishment.
yeah.
And I'm
So-
just assuming those were state jails. I'm just going off Mr. Coleman's notes.
So if they were enhanced, if it was enhanced to a state jail, and then prior felony convictions enhanced it, the punishment up to a third, then that one would be considered a third, but I'm not real sure. There's the possibility, it's probably something I would have to do a little research on as well as Mr. Wilkerson. Mr. Coleman is of the opinion that because it was punished as a third degree, what was the punishment, Anna?
4.
For TDC.
Yes.
So because it was punished as a third because of those priors, it's Mr. Coleman's status or his position that you would be considered a habitual offender in the murder case with a minimum punishment of 25 years. I'm not 100% sure of that. I think Mr. Wilkerson needs to do some research and has a different position. At a minimum on that case, you would be considered enhanced with a minimum 15 up to 99 years or life. So that's your minimum. Potentially, because of that evading, it could change to a 25. Do you understand?
What does evading have to do with motor charge?
It's your prior criminal history. It doesn't have anything to do with it other than the fact that
And
you,
why is it being enhanced based on?
because you keep breaking the law. And so you don't get to do your time and say, it's all over, don't use it against me. That's how state law works in Texas. If you keep violating the law, then your punishments get worse.
Yeah, but I'm accused of this, not.
That's right. And so that's why I want to make sure.
Oh, you just informed me.
I'm just informing
Yes,
you,
ma'am, I understand.
if you go to trial and a jury finds you guilty and those prior offenses are true, that you committed those prior offenses and then you were convicted of them, for sure at that point, it would be minimum 15, possibly minimum 25, depending on some legal issues that your attorney will look into, as well as the state's attorney. Do you understand that?
Yes, ma'am.
Okay. Looks like the state has made an offer, if you wanted to enter a plea of guilty in your cases, to a 40-year term. I have 2 plea bargain rejections here that you've signed with Mr. Wilkerson, that they've offered you a 40-year term in each of your cases to run concurrently, which means together at the same time. You've got every right to reject that, move forward with trial. Is that what you want to do? All right, we're going to get your case set for trial. I do want to make sure you understand, Mr. Johnson, that after today, I will not accept this agreement unless there is new information that is brought forward that the attorneys don't know about now. But if they do, then we'll discuss it. Other than that, this plea offer is off the table, and you can either plea open to the court or to something else or go to trial. Okay?
Judge, this week, while Mr. Coleman is in trial, I'll get with Mr. Wilkerson, we'll kind of exchange an email with respect to discovery. This file seems very small, there might be an expanded file upstairs. If not, I would anticipate maybe a few more things coming, and we'll get it well.
There is an expanded file upstairs, and I believe he's turned everything over to me. The only question, there was a jump drive that was brought up at the last proceeding, but I believe he gave that to me a couple of days afterward, and that I've gone through it.
So you've got everything as far as you know. If you'll, yeah, I would appreciate that if y'all will double check.
So there are some evidentiary issues that Mr. Johnson, I guess, represents aren't true as far as location data and things of that nature, and that's just something that.
That's up to a jury.
It is what it is.
Yeah.
It's up to the jury to determine, so.
Sure. And that's what Mr. Wilkerson's for, is to point out any issues in the state's case to a jury, and then it'll be left up to the jury once they hear all the evidence that's provided. Okay? All right, you can go back with the bailiff.
Y'all have a good one.
Thank you, sir.
Thank you, Your Honor. Excuse.
Yes, sir.
Thank you,
Thank you.
Judge.